This is City and State TV. I'm Albany Bureau Chief John Lentz. I'm joined today by Lou Colleti, President of the Building Trades Employers Association. Thanks for joining us today.
It's a pleasure to be here, John.
And your organization represents contractors, building contractors in New York City, and one big issue for you is the scaffold law. Tell me a little bit about the law and what your concern is about it.
There's no single more important issue on our agenda this year than reform of the scaffold law to our completely 2,000 contractors. Insurance costs are exploding. It threatens economic development. Basically what the law says is that irregardless of what the circumstances are with respect to any accident on a construction site, the owner and the contractor are 100% liable. It's called strict liability. We're the only state in the country that has the strict liability standard. It was created 130 years ago when there were no protections for worker safety, when there was no OSHA requirements, when there were no building departments with regulations. It's an antiquated law whose time has come to get written off the books.
Now, it is a controversial law, and there are union folks and trial lawyers that support it. And I've been told that that absolute liability standard, it only applies if the contractor fails to provide adequate safety supplies and adequate safety training.
That's 100% wrong. That's what the trial attorneys are spinning. That is not accurate at all. Under the current law, when you go to court, the only time that we get an opportunity to present any information is in determining whether or not it is a 240 claim or not. If the judge makes a ruling that it's a 240 claim, the only thing that gets talked about is how much money gets awarded. We have no rights in a court of law to present any evidence we may have. The other issue that the trial attorneys are spinning is that we're trying to repeal the law. Again, that is 100% inaccurate. We are attempting to amend the law in a way that will preserve the rights of any injured worker to file a lawsuit.
Now, this year you are making another big push to reform the law. And one example that's been cited is the New York City School Construction Authority. And their insurance costs, there have been reports out that those insurance costs are going up. And critics of the law say it's tied to the scaffold law, these huge settlements. What's the push going to be like this year? Do you think it'll be successful in Albany?
We certainly hope so. I don't know how we're going to build new pre-K classes, which seems to be the topic that both city and state officials are focusing in on, without spending more taxpayer dollars, without reform of this law. The SCA's insurance costs for 2014 will be $234 million for 1 year. Last year, it was $85 million. They are about to go to the City Council with a new 5-year capital budget, and it will cost over $1 billion to fund lawsuits so lawyers can get rich and claims. That's absurd. So when you do the math, it translates into, assuming that it's a $200 million premium every year, we could build 8,000 new classroom seats, pre-K and all, with that money that's now going to be spent on legal fees.
And that $1 billion estimate, that's sort of over 5 years, correct?
That's correct.
Okay. And what reform would you like to see in Albany? And is it essential that that be in the budget?
We would like it to be in the budget because I think the faster that we get the change, the sooner we can begin to see insurance premiums begin to decline and more jobs to be created. We're not going to give up the fight, especially with the School Construction Authority. I mean, I talked about the cost for and the loss of classrooms that will be built. This is also going to have a major impact, not only on all contractors, but in particular to growing minority and women-owned contractors. The School Construction Authority has probably the best program in the state. Over the last 10 years, they've awarded $1.7 billion to MWBE over 800 contractors. Part of the reason they've been able to grow is because the SCA has been able to provide insurance coverage for them. If they have to go back into the market where 4 years ago, there were 10 insurance companies that were willing to write liability insurance. Today, maybe there are 2. They're out of business. And if that message doesn't resonate with legislators to get something done that doesn't hurt anybody, I don't know what is. It's time for the state officials to stop responding to the trial attorneys and start responding to their constituents who want to create jobs, create businesses, and create more classroom space.
Now, you say it's not repeal of the law that you want, but you want reform. What exactly would the reform be?
Right now, the law, the standard for the law, it's called absolute liability. It means there are no circumstances by which, if it were an employee's fault, if they were directed not to climb a ladder, they did it. They're not wearing the proper safety equipment after they've been given the proper safety equipment. It doesn't matter. The owner or contractor pays. All we're asking for is in those situations where the worker does not comply with the safety provisions and the safe work site that is provided for them, we have an opportunity to present that to the jury. If the jury finds that they don't buy our case, that's fine with us. But right now, we don't even have that opportunity.
And again, looking at the politics of it, is there any indication that the governor would support this change?
I think the governor is very interested and has been a leader in just creating an environment to improve the business climate. So I think he will be receptive, and I think that he's got to have a partner. He's got to have a legislative partner.
Luke Colleti, thanks for joining me today.
Thanks, John.